Hello! Today on Subrogation, we're going to discuss the liability of serving alcohol or other substances. I'm Kim Rathbone, your host for today. It may sound like a bit of a stretch to hold a bar or the host of a party liable for serving alcohol when damages occur, but the whole point of this is to try to protect the public. So the first kind of liability we're going to talk about is Dram Shop Liability. That's where a bar or the employee of a bar can be held liable for injuries that are caused by the intoxicated person to any third parties or even to themselves. Most states recognize this kind of liability, but there are some states like Louisiana and Virginia that don't. For those that do, the standard is whether the bar or the employee of the bar knowingly served an intoxicated person, and they didn't take any measures to try to increase the safety of that person when they were either headed home or interacting with others, like encouraging them to Uber home or finding other places to stay in order to sleep off the intoxication. Generally, this liability is really only for one particular incident, but there are some states that will recognize if there is habitual intoxication that has been facilitated. The standard generally is that of a reasonable person. So you need to think about, was the bartender or owner of the bar acting reasonably under the circumstances when they had an intoxicated person that was there. Now, proving this is different in different states. There are some states that are particularly strict, like Connecticut, where you don't have to prove that the sale produced the intoxication that caused the injury. And there are plenty of circumstances where it isn't necessarily getting in a car and driving home. It could even be liability for something like a fight at a bar and personal injuries that occur after that. In terms of damages, there are several rules that apply. One of them is that you cannot mitigate your damages by saying, hey, this person drank at other places before they came to our establishment to drink. Now, they might be able to try to recover some money from the other bars that had served that person that night, but they can't just mitigate their damages to the party that is injured. There are varying standards throughout the different states in terms of what you need to prove. Sometimes it's just partly causing the intoxication that will create that liability for the bartender or the bar. But most of the time, it's materially causing intoxication. So there has to be a major role that the bartender played that wasn't reasonable with regard to the circumstances. For the jurisdictions that do recognize a cause of action for habitual intoxication, those are generally saying that the bar needs to have materially aided in the habitual intoxication. So a bar isn't the only type of entity that can be held liable when damages are caused by an intoxicated person. Even the host of a party can be held liable for damages when they are serving an intoxicated person and they cause injuries to a third party or themselves. And that's called social host laws. What that involves is when the host of a party furnishes alcohol or condones the consumption of alcohol in their home. Now, they don't have to have any type of financial gain, and they also don't have to have any kind of special relationship with the person who is intoxicated. They just need to facilitate or furnish alcohol or other substances. There are many states that recognize social hosts liability, like Washington or New Jersey, but there are plenty that don't as well. So here's what it involves. The social host needs to know that they are providing alcohol and other substance to an intoxicated person. And the standards are different in different states. In some states, the social host needs to know that the guest is driving. And in other states, they need to know that the circumstances manifest reckless behavior when they're serving alcohol or other substance. And it really goes back to the reasonable person standard. Would a reasonable person have provided alcohol to that intoxicated person at that time? Of the states that don't recognize normal social host liability, there are plenty that will recognize it if there are minors involved. And a couple of states that are examples of that are Ohio and Tennessee. Now, the liability for serving alcohol or other substances to a minor doesn't just have to be a parent. It could be any kind of an adult. And you can't, in those states, serve or even furnish alcohol, which just makes it available to others if there are minors that might be drinking or using substances. And this is in more circumstances than knowing the minor will get in a car and drive. There's a recent case in Ohio where an adult decided to serve alcohol in their own home because they felt it was safer than kids going and obtaining alcohol in a public place or not as safe of a place. But all the children contracted meningitis in that time, and the adult was held liable for all of the injuries. As a fellow parent, I can understand wanting your child to be safe and trying to make sure that even if they're going to be drinking or using other substances, that it's at least in a safe place in your own home. But there are plenty of states where there is liability for that, and you need to be aware of your state and how they assess serving minors with this liability. So how would I use this if I'm a claims adjuster? If I'm investigating a claim and alcohol is involved, I would want to find out all the places where the intoxicated person was drinking. So I would be speaking to any witnesses, anyone that was at the party itself or the bar itself that I could get a hold of to figure out where are the locations where any drinking or using of substances was occurring. This might create a third party that you can go after to recoup the losses that are paid by the carrier in a claim. I hope you've enjoyed this episode of On Subrogation. Thanks for listening. I'm Kim Rathbone. That's the long and short of it.